are dismissed. People's lives are ruined and destroyed. Yet your own in-house law firm, without a doubt, falsely accused me.
You have represented as a fact that the Office of Lawyer Regulation is our in-house law firm. I think that is a totally inaccurate representation. The Office of Lawyer Regulation is an agency that prosecutes violation of the ethical rules, but by no stretch of the imagination, for me, is that our in-house law firm.
Well, Your Honor,
I can never get advice from them.
Well, Your Honor, I find that to be somewhat amusing, and I'm not trying to be disrespectful, because they characterize themselves as your in-house law firm in this case. That was quite some time ago. If that was your opinion, I would have thought you would have voiced it well before today. But that wasn't my characterization. That was their characterization in this very case, in a brief I know that you received. So I don't think it is at all unfair for me to have characterized them in that fashion. But what's even more important is, Your Honor, there's no doubt that the director of this firm, be it your in-house law firm or be it something else, it is supervised by this court. And the director, without a doubt, fabricated. He falsified the most critical assertion against me. It was false. It can be easily shown as being false. It has been shown to you to have been false on numerous occasions. And yet this court did nothing, even though this court had to have known that his falsification would destroy my reputation, would destroy me financially. I have plenty of children, Your Honor. In fact, that's where I'll end up with. Back on September 29, 2003, I alerted this court. At that time, I told this court, I tremble at what I find myself faced with at this juncture. I have 9 children, and my wife and I expect a 10th next spring. I do not lightly put myself in a situation where, for all practical purposes, my means of supporting my family may be seriously jeopardized. But on the other hand, what has occurred in the above-captioned case is such an outrage of justice and common decency that my responsibility as an attorney for Adam Raisback and as a citizen compels me to act. The only thing about that paragraph that would have to be corrected would be now I have 13 children versus 9. Everything else is the same. And in that very letter, I didn't just make some wild allegation. I detailed it, and I provided this court with the very transcript pages that proved Judge Higginbotham had falsified the record in order to cover up for prosecutorial misconduct, dishonesty on the part of the Dane County District Attorney's Office. And this court did nothing. And instead, I have found myself, I guess, my finances seriously jeopardized. It'd be more accurate to say wiped out. I suppose I'm up to my time.
Well, you have a few more minutes. Your time is up at a red light.
Okay.
Then you have 10 minutes after Ms. Falk
If
speaks.
there is any, are there any questions?
Well,
No questions? No?
One of the things, Mr. Sommers, is you have been, I believe, advised that your allegations regarding the conduct of OLR were going to be taken up, if you wish, after this proceeding, and that they were 2 separate proceedings. So I wanted to make that clear to you.
Your Honor, by what basis does this court do so? The Supreme Court rules, from what I see, gives no authority for that to take place, number 1. Number 2, think about what has been said. For 4 years now, this court has stayed its own rules. Is that not a green light for OLR to continue in the systematic dishonesty? As I told the court, that is what would occur, and that is what has occurred. It never stops, as I even showed in my reply brief, even up to this very moment. They make assertions that not only are false, but assertions they know that every single one of you knows it's false. Is it not reasonable to conclude that OLR would view the whole thing as, we got your back, Sommers has to go down. Do whatever you can. We must discredit him because he is too much of a danger to what goes on and to what this court has permitted to go on. I believe any rational, fair-minded person would see it in such a way. And I don't know why, and I don't know by what authority you have to stay it. What right do they have to engage in systematic misconduct? What right do they have to engage in perjury? What right do they have to withhold documents and say, well, sometime down the road, we're going to deal with it? I don't think that's just, especially when you're talking about destroying a man's profession, destroying a man's reputation, wiping him out. This is a very intelligent court. This court knows what OLR has done. This court knows that that's why we have rules that are supposed to be put into place. And I do not understand, for the life of me, why they would be stayed to, basically, for the benefit of attorneys who, in this court's name, have been proven to engage in the most systematic dishonesty. I do not understand.
Mr. Sommers, I have a question. There were 3 counts that OLR brought against you. My understanding is the referee found that you were not violative of the first count, but found that you were violating the code in regard to 2 counts. One of those counts had to do with what occurred in front of Judge Bukowski and what allegedly you said to Judge Bukowski. Do you take issue with that particular finding of the court, of the referee?
Sure, I take issue with it. Any fair-minded person would take issue with it. The fact, and why I take issue with it, which I'm assuming you're asking me, is because what I said to Judge Bukowski that day, was it disrespectful? I'm not going to argue that it wasn't. Was I out of hand? I won't argue that it wasn't. But what I said that day, and this is what I've been charged with, and this is the clever thing, is as if what I said was false. As if what I said was in reckless disregard for the truth. And that is false. Everything I said that day, I said in good faith. And everything I said that day has been substantiated. Judge Bukowski, by his own admission when he was deposed, was presented in formal motion with evidence of misconduct after misconduct after misconduct, which he has admitted would have violated the due process rights of Adam Raisback. When he was judged, he did nothing. Nothing at all. When he was deposed, he was asked why. He refused to give an answer. And Judge Bukowski has conceded that there is evidence of perjury. He has conceded that 4 affidavits submitted by the Dane County District Attorney's Office were, by the evidence, false. He has conceded that the Dane County District Attorney's Office, up to Brian Blanchard, withheld exculpatory evidence. And yet he did nothing. And so with that, and the last fact I'll put in is, again, too, with the referee, remember, in the findings that he made, that was after he disregarded 6 days worth of evidentiary hearings that were held, to which he decided after the fact they didn't count. And with that, I suppose my red light.
Counsel 40.15 says failing to maintain respect due to a court or judicial officer.
Your Honor, I'm sure this court has to know, from the very beginning of this case, I said that if that's what I'm accused of, I would admit to it. I told that to OLR, but that's not why the thing moved on. What OLR insisted was that I admit that basically that I concede, otherwise I guess face room, but what I concede is that what I said in court was not in good faith, and that is false. Everything I said that day was true, and I have proven it to be true over and over and over again. And again, if evidence doesn't count, well, then what can I do?
Counselor, who was it that required that you concede that what you said before Judge Bukowski was not truthful?
OLR actually said that in order for basically that count to be taken away. It came up in front of the referee on a number of occasions. The record is very clear that I said, if I'm being accused of being disrespectful, I conceded. OLR said, no, I would have to concede that the statements that I said in court were in reckless disregard for the truth, to which I said no. I do want some rebuttal time because given how these proceedings have played out, she will make a number of statements that would be categorically false. I want the chance to respond, so how much time do I have left?
You'll get that chance.
Well, thank you.
You're now on our time.
Okay.
When we ask you questions after the red light.
All right, I didn't know that.
I know. Those are the rules of the court, and that's fine. And do you have a question?
Yes, I have a couple of questions with regard to count 2, which was the subject of Justice Crooks's question or your response. As I understand count 2, and correct me if I'm wrong, that's why I'm asking the question, that I understand it was alleging that you engaged in loud, disorderly, contemptuous, or insolent behavior during a hearing before the circuit court on May 24th, 2004, in violation of one of the SCRs, that you engaged in conduct intended to disrupt a tribunal in violation of one of the SCRs, it's 20.8.2a, that you made a statement that the lawyer knows to be false or with reckless disregard as to the truth or falsity concerning the qualifications or integrity of a judge, and that, etc. So it sounds to me like count 2 covers quite a bit of territory, which includes both the violation of disrespect to a tribunal and disorderly, contemptuous, or insolent behavior before a judge, as well as the making a false or reckless statement with disregard of the truth. Is that your understanding of count 2? And if it is, then it sounds like you're acknowledging at least a partial violation. Can you respond to that, please?
Yes. First, it is my understanding that these are like the elements. And again, one of the elements, the way that it was portrayed to me, and it had come up, was that I would have to concede that I made a statement with reckless disregard for the truth. That never happened. That's false. Second, in regards to whether or not my behavior was disruptive and insolent and so on, I concede that although this is a subjective matter, somebody in good faith could see it that way. I also, though, believe that mitigating factors are, in terms of justice, have to be seen. And it must not be overlooked that throughout Raisbeck and prior to that proceeding, there had been significant attempts to bully me, to browbeat me, to intimidate me, even twice to falsely accuse me on the stand, one even being right before the outburst. Judge Perkowski knew I hadn't engaged in any innuendo. If you look at when the so-called outburst took place, it was right after he says to me something to the effect, you engage in innuendo and you can accuse anyone of anything. He knew at that moment in time, I had given him roughly a dozen, I believe it was, or so, affidavits. I didn't make any reckless allegations. In fact, the whole issue of that day was, would he permit me to prove what people had put forth in a subpoena? He was saying, you can't prove what they put forth in the subpoena, not only at an evidentiary hearing, but at a trial. That's right, at a trial he was saying this evidence can't even come in. I hadn't accused anybody by innuendo. I went out of my way to do it by the book, and I went out of my way to get evidence. 12 people. We had Kevin McCoy. That's why this whole McCoy thing, which the referee falsified, is really, it just sins against the light. Kevin McCoy was one of the people there to testify to how he'd been browbeat, testify to how they tried to coerce him with a fraudulent warrant in order to commit perjury against his own friend. Something as immoral as the way as I see it, something as destructive to our court system. He was there to testify. And Judge Perkowski, despite all of his obligation under the law, refused to let him and other individuals there that very day and on a prior day testify to what had taken place. There was no innuendo, Your Honor. Everything I said was true, and Judge Perkowski knew it. And he knew he was falsely accusing me, and that's what he did. And should I have lost my temper? No, I shouldn't have lost my temper. That's right, I am a flawed man, and I apologize for Adam Raisbeck. I got him off, but I probably could have done a little bit better job, but I'm a flawed man. But I did the best I could in light of all the criminal conduct and all the things that were taking place. And I came to this court. I pleaded with this court. I showed this court the state statute where this court had the power to intervene. And this court did nothing. And instead, I